Thank you for visiting the Waterkotte website and our Property Crime Defense Lawyer in Missouri website page. Regardless of the crime, we believe everyone is entitled to the best possible legal defense in the state of Missouri. We have created this audio version of our website page to help you better understand our services and protect your future, freedom, and reputation. If you have been charged with a property crime in the state of Missouri, we can help. Don't face the state and court system alone during your property crime charge. Contact one of our Missouri property crime defense lawyers today at 314-900-HELP to protect your rights and future. Waterkotte is committed to handling all property crime cases with confidential care and understanding. We are not here to judge you. We believe that everyone in Missouri, regardless of the crime they have been charged with, deserves an aggressive legal defense and to have their legal rights protected. With that being said, let's discuss hiring our property crime defense lawyers in Missouri and setting up a free consultation with our attorneys. Property crime defense lawyers in Missouri. Missouri law prohibits using, damaging, or taking someone else's property without permission. Depending on the nature of the offense and the extent of the damage, you could face a felony conviction and imprisonment. Waterkotte's Missouri criminal defense lawyers represent those accused of property crimes ranging from vandalism to arson. We have extensive experience handling these cases and a long track record of obtaining positive outcomes. Property crimes in Missouri. Criminal laws have always protected life and property. Arson and larceny, the technical term for theft, were felonies under the common law, and trespasses to land and personal property were grounds for a lawsuit. Missouri has several criminal offenses that punish offenders who interfere with the possession, use, or value of another party's property. These offenses don't require proof that the accused benefited from their actions. It's enough to show that the accused infringed on the property owner's rights. We help people just like you when facing life-altering criminal charges. Speak to a criminal defense lawyer today at 314-900-HELP. Missouri statutes covering property crimes. The Missouri Revised Statutes outlaw several property crimes in the chapter arson, burglary, trespass, and related offenses. The state classifies property crimes separately from theft crimes. Crimes involving taking property without permission are detailed in the chapter entitled Robbery, Stealing, and Related Offenses. The following laws apply to interference with property rather than theft. Property damage. Missouri has two charges penalizing property damage. First-degree property damage occurs when a person knowingly commits any of the following acts, causing more than $750 in damage to another party's property. Causing more than $750 in property damage to defraud an insurer. Damaging a motor vehicle while stealing items inside it. Damaging, modifying, or destroying an ATM, or rendering it inoperable. The second offense applies to the accused's property as well as the property of others, for example, crashing their own car to collect insurance money. The third applies even if the damage value is low. Second-degree property damage is the catch-all charge for all other forms of property damage, including knowingly damaging another party's property, damaging property to defraud an insurer. Missouri doesn't use terms like vandalism or criminal mischief. All these fall under property damage statutes. Institutional vandalism. If a vandal defaces or damages certain types of property, they may face institutional vandalism charges. This includes vandalism of places of religious worship, cemeteries, military monuments, or memorial grounds, schools, hospitals, or clinics operated by religious groups, school buses, public monuments, or public structures. Arson. Arson occurs when someone damages or destroys a building or inhabitable structure by starting a fire or explosion. First-degree arson involves knowingly starting a fire or explosion in an occupied structure. Reckless or criminally negligent fires may also qualify. Tampering. Tampering refers to the unlawful use or disruption of services or vehicles. First-degree tampering includes damaging or disrupting property used for utilities, health services, safety protection services. It also includes possessing or operating a vehicle without the owner's consent. Second-degree tampering includes causing substantial inconvenience to another's property, unlawfully riding in or on another's vehicle, illegally connecting to or interfering with a utility, manipulating a utility meter to avoid charges. Missouri separately criminalizes theft of services, so connecting illegally to a utility may result in both tampering and stealing charges. Trespass. Trespassing occurs when someone enters or remains on another's real property without permission. First-degree trespass requires knowing intent, while second-degree can occur accidentally. Trespassing can be charged even without damage or knowledge by the owner. Damaging crops. Under Missouri's Crop Protection Act, offenses include intentionally causing crop loss, damaging, vandalizing, or stealing farm property, accessing crops under false pretenses, interfering with or duplicating crops without consent, knowingly controlling or destroying crops without permission. This law provides special protections beyond the general property damage statutes. Burglary. Burglary is often confused with theft, but legally refers to unlawful entry with intent to commit any offense. It does not require theft. First-degree burglary involves being armed, entering an occupied structure, or threatening harm. Second-degree applies to all other unlawful entries. Defenses against charges of property crimes in Missouri. Your criminal defense attorney can employ many criminal defense strategies, such as claim of right. Missouri law allows you to assert a claim of right to defend against property crime charges. A claim of right simply means you had ownership or other rights in the property involved. You can't damage another party's property if the property belongs to you. This defense also applies to reasonable mistakes. Specifically, you can claim you reasonably believed you had the right to use, damage, or destroy the property even if you didn't. You might be liable to the owner for their losses, but you may escape criminal prosecution. Consent. Consent is given when the owner permits you to perform the allegedly illegal act. For example, you can't unlawfully use someone else's vehicle if you're a parking valet. However, this defense only extends to the consented acts. Thus, a valet would have consent to drive the vehicle to the parking lot and park it, but not to go on a joyride. Necessity. You can raise the defense of necessity when you must perform a prohibited act to avoid greater harm. A classic example of this defense involves boating during a storm. If you tie your boat to a stranger's dock so you can get off the water safely, you might avoid prosecution for trespassing and property damage by asserting necessity. Possible penalties for property crimes in Missouri. In Missouri, property damage offenses can be charged as either felonies or misdemeanors. The specific penalty depends on the crime's severity, intent, and amount of damage involved. Possible penalties for property crimes in Missouri. In Missouri, property damage offenses can be punished as felonies or misdemeanors. The potential penalties for a property damage conviction include the following: property damage to an ATM for financial info or repeat ATM vehicle offense is a Class B felony, 5 to 15 years in prison. Damage over $750 to an ATM is a Class C felony, 3 to 10 years in prison. Property damage against law enforcement or first offense, damaging a vehicle during theft, is a Class D felony, up to 7 years. General first-degree property damage is a Class E felony, up to 4 years in prison. Second-degree damage targeting law enforcement is a Class A misdemeanor, up to 1 year in jail. Second-degree property damage without special circumstances is a Class B misdemeanor, up to 6 months in jail. Felony-level property crimes can impact your record and future even without jail time. Charges vary by victim, intent, and past offenses. A lawyer can help reduce the penalties. Why choose Combs, Waterkotte to defend you from property crime charges in Missouri? The attorneys at Combs Waterkotte have managed more than 10,000 cases over their careers. These include a diverse array of property crimes, from minor vandalism to first-degree arson. Our attorneys include a former prosecutor. We can use our experience and knowledge to craft a legal defense that fits the evidence available in your situation. How we fight charges alleging property crimes in Missouri. We'll start by learning your side of the story. Property damage claims often result from mistakes, pranks, or acts committed in the heat of the moment. We'll gather evidence to support your version of events and use it to craft a robust defense strategy. We'll then use this defense to negotiate for a dismissal or reduction of your charges. If we can't secure a dismissal or fair plea deal, we won't hesitate to take your case to court. There, we'll seek to undermine the prosecution's case and present evidence supporting your position as we argue forcefully for an acquittal. Contact Combs Waterkotte to get a skilled defense for your Missouri property crime charges. Property crimes often carry harsh punishments, including years in prison. Contact us online or at 314-900 HELP today to discuss your charges and the possible defenses you can assert under Missouri law.